1 in 6 Australian women and 1 in 16 men have been subjected since the age of 15 to physical and/or sexual violence by a current or previous partner. In 2021, the QPS responded to more than 107,000 occurrences of domestic and family violence. That's 1 every 5 minutes. Assistant Police Commissioner Brian Codd estimates that frontline police officers in Queensland are spending 40% of their time attending to domestic and family violence incidents. These statistics establish that domestic violence remains one of the most prevalent social, cultural, economic, public health, and legal issues that we face today. The Domestic and Family Violence Protection Act 2012 currently defines domestic violence as behaviour that is physically, sexually, emotionally, psychologically, or economically abusive, threatening or coercive, or behaviour that in any other way dominates another person, causing fear. This presentation will explore the two key agencies for our state's prevention and redress of domestic violence, the Queensland Police Force and court systems. We will recognise that the legal responses provided by these sectors, specifically police response and civil protection orders, are significant mechanisms of the Queensland response to domestic violence. However, the reality of their operation and the emotional and psychological impact on stakeholders has established that these responses are inadequate in responding to both victim and perpetrator needs, including protection, recovery, and support.
Therefore, we will be providing recommendations for policy development and law reform, which can be made within both sectors that can reorient the law to better embrace the principles of therapeutic jurisprudence in the handling of domestic violence cases. Developed by law professors David Wexler and Bruce Winnick, therapeutic jurisprudence is defined as the study of the role of the law as a therapeutic agent. It focuses primarily on the legal process and its effect on victims and offenders. In essence, therapeutic jurisprudence examines the extent to which legal rules, legal procedure, and the actions of legal actors combine to produce therapeutic or non-therapeutic consequences.
Therapeutic jurisprudence therefore accompanies the rethinking of traditional adversarial models of law and their effects, and instead seeks to incorporate knowledge of other non-legal disciplines into the legal system and to consider alternative legal approaches and outcomes. We have chosen this as our lens because therapeutic jurisprudence views the actions of legal actors, such as courts and police officers, as important therapeutic agents who are responsible for shaping the law's effect. In the context of domestic violence, therapeutic jurisprudence would be particularly relevant for these role players to meet a variety of needs, ranging from offenders' accountability to safety and restoration of victims' physical and emotional well-being, and the protection of all parties' basic rights.
The first responders to domestic violence incidents play an essential role in ensuring the immediate and ongoing protection of victims. Part 4 of the Domestic and Family Violence Protection Acts deals with police functions and powers. Pursuant to Section 100, if after investigation a police officer reasonably believes domestic violence has been committed, they must consider whether it is necessary or desirable to take specific actions to protect the person from further domestic violence. Such actions include applying to the court for a protection order, taking the perpetrator into custody, or taking any other appropriate action. Interactions with police officers and victims represent a unique opportunity to secure the safety for a victim of domestic violence, both immediately and on future occasions. A report by the UQ School of Law interviewed 61 victims of domestic violence, and they discussed how their cases were handled by law enforcement. Although some of the women in the study had reported positive experiences with the police, most of the women had reported negative responses. These included rudeness, lack of compassion, not listening to the victims, and failing to provide them with further advice. The task force in the Queensland Not Now, Not Ever report echoes this, with stories of victims not being believed or of abuse being too trivial and a waste of police resources. The result of such inadequacies is that domestic violence victims are no longer willing to come forward for help from police, many choosing to suffer in silence. In such circumstances, these interactions with police officers and the current reported responses to domestic violence produce anti-therapeutic responses. Dennis Sarkozo explained, and I quote, From a cognitive and therapeutic jurisprudence perspective, when police respond ineffectively, offenders are reinforced to deny their behavior while the battered person continues to feel a sense of helplessness. Therapeutic jurisprudence, the goal is to make decisions that positively affect behavior, such as to begin the healing process for victims of domestic violence. Police training into how to effectively respond to both victims and offenders in domestic violence incidents is an essential step from a therapeutic jurisprudence perspective. By making effective use of concepts of therapeutic jurisprudence, it may be possible to not only begin the process of re-education of the offender and the healing of the victim, the moment of police contact.
The other key role player in frontline response to domestic violence is the Queensland Magistrates' Courts. Once an application for a protection order has been issued, either through the police, the victim themselves, a lawyer, or a friend/family member, this is when the courts become involved. Court-granted protection orders have been a cornerstone of the Australian response to domestic violence for almost 30 years now. The objective of these orders and the court involvement is to provide victims of domestic violence with protection from future violence through facilitating access to civil law. Once an order is made, the system then works on the presumption that the necessary prevention measures have been applied to provide for the ongoing safety of victims. However, the reality for some is that domestic and family violence continues. Since the beginning of 2019, 134,694 protection orders have been granted across Queensland Magistrates' Courts. Within that same period of time, the Queensland Courts website reports almost 78,523 contraventions of existing protection orders. In an Australian study conducted across police officers, lawyers, magistrates, and victim advocates, they were asked about the efficiency of protection orders. The majority of each professional group were of the view that protection orders only sometimes kept victims safe. Furthermore, most of the professionals perceive the implementation of breach penalties kept victims safe sometimes. However, a third of police, lawyers, and victim advocates believe the implementation rarely or never kept victims safe. It has been suggested that these orders are even less effective for offenders with a history of crime, violence, and mental health issues.
In another study conducted by the Women's Safety and Justice Task Force, key stakeholder groups were asked to identify how Queensland's current approach to protection order breaches could be improved. They reported a clear consensus on adjusting their focus to intervening to change the root of perpetrator behaviour, as it was argued that the needs of vulnerable groups cannot just be met through mere punishment of offenders. This would require a significant new direction for the judiciary, from acting as neutral adjudicators, determining and evaluating the facts in a case and assessing it against the law. Instead, it would encourage them to be a large role player in the rehabilitation of offenders, encouraging them to enter and remain in treatment by connecting them to community resources, motivating them through creative uses of the court's authority to accept needed services and treatment, and monitoring their progress in ways that help to ensure their success. This may also allow courts to assess and manage offender risk based on an actual assessment, which would ultimately assist in increasing victim safety. Through targeting recurring problems that seem to be the product of behavioural, psychological, or psychiatric difficulties or disorders, and intervening to prevent their reoccurrence, the courts would be seen to achieve an overall goal of offender rehabilitation. This approach aligns closely with the principal components of therapeutic jurisprudence, as identified by Winnick and Wexler. These include 1. Ongoing judicial intervention, 2. Close monitoring of and immediate response to behaviour, 3. The integration of treatment services with judicial case processing, 4. Multidisciplinary involvement, and 5. Collaboration with community-based and government organisations.
There are many criticisms of how therapeutic jurisprudence would operate when we apply it, especially for those sectors. Critics have argued that when legal actors, especially police officers and court, become one-stop social problem-solving centers, they may begin gambling outside their field of expertise. First, Recent criticism that have been made by legal practitioners and academics have expressed that therapeutic jurisprudence does pose a significant risk to the use of due process within the criminal justice system. These risks have the possibility of affecting the rights of victims as well as the defendant. The reasons for these risks are the speed of expansion of the number of criminal justice initiatives, such as problem-solving court, and the range of these initiatives. The rapid expansion of these initiatives and programs and the way which they have been implemented pose the risk that they are incompatible with the core principle of therapeutic jurisprudence. If this incompatibility relates to the inconsistency of used due process right, then conflation between those two innovation is developed. Secondly, implementing therapeutic jurisprudence in the court system may be viewed as a soft approach to crime, which is defendant focused. The focus on the renewed therapeutic jurisprudence criticism in the United States has been on the right of the defendant. The thrust of these vigorous objections are beginning to eager to focus on treatment or on therapy. Defense lawyers in problem-solving courts have abandoned their adversarial obligation to monitor the legal and procedural rights of their client. Similarly, according to this rationale, judges have sacrificed their impartiality of penalistic concerns for the non-legal welfare of the offenders.
Domestic violence victims should not feel worse off when approaching police. The existing bad culture surrounding domestic violence is still prevalent in the way police handle domestic violence issues. The police needs to offer a more emotional and sympathetic approach towards the victims of domestic violence. However, this would require police retraining in order to understand the dynamics of domestic violence in order to be able to deal with domestic violence situations appropriately. Guidelines police currently follow are too vague, and therefore more prescriptive information is required to guide officers in both detecting and dealing with domestic violence. Additionally, more importance needs to be placed on domestic violence with more experienced officers attending the scenes of domestic violence. For therapeutic jurisprudence programs to produce effective results, the Criminal Act needs to be condemned and not the offender. Regarding the judiciary, our first recommendation is that the Queensland Government design, establish and adequately resource a statewide network of perpetrator intervention programs. These programs need to be robust, high quality, targeted intensive programs mandated for any respondents to a protection order. They would also be available for anyone else who identifies their own problematic behaviour and willingly wants to participate. This network of programs would recognise that changing perpetrator behaviour is paramount to keeping victims safe from domestic violence. The statewide network of programs would include trialling, testing and evaluation in order to develop new approaches and refine existing programs. This would also help build up a knowledge base about what works and doesn't work in making perpetrators being held accountable for their actions. Victims would feel safe as a result. Regarding the judiciary, our second recommendation is the use of domestic violence specialist courts. The sole purpose of these courts would be to reduce the occurrence of domestic violence cases in the community, protect victims, and monitor compliance with protection orders. This is necessary as the current court system has been viewed as ineffective when dealing with domestic violence cases, due to using non-therapeutic processes. Non-therapeutic processes act to restrict and limit the processes and procedures that can be used, which results in unsatisfying results for these domestic violence cases. Finally, domestic violence specialist courts would use therapeutic jurisprudence processes to assist the victim's mental health, well-being, and experiences with the legal system.
To conclude, this presentation has focused on how significant and harmful domestic violence is in today's society. The Queensland Police Force and court systems were both explored with the purpose of using these to prevent the prevalence of domestic violence situations. The police were seen to be a key factor as to why domestic violence victims do not seek legal help and feel inadequate. The courts were evaluated as a key factor through their use of protection orders and how they are constantly breached. Therapeutic jurisprudence was implemented as a possible solution to both the police and courts. Recommendations about integrating therapeutic jurisprudence into these institutions were developed, and it was proven this integration will assist the decrease of domestic violence. Thank you for listening.